Adjournment request, if any, from item number 1 to 9.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 2, lordship. Today, my senior has some difficulty, lordship.
It will remain on the board.
Lordship.
Next Tuesday.
Lordship, can the matter be taken up after 3 weeks, lordship?
Why?
My senior has some difficulty till 16th, lordship.
At the request of London also. Start to 6 weeks.
6 weeks.
Much obliged, lordship. Lordship, I beg to mention item number 456. Lordship, senior is out of station. Lordship, kindly pass over the
Out of
matter.
station or not feeling well. Yesterday it was mentioned that Mr. Sahiwala is not feeling well.
Lordship, out
He is
of,
out of station.
lordship, he is a Isol once, lordship.
Yes. Arjun. Password for the thing. Remain on the board.
Yes. From item number 10 to 17, adjournment request.
There's a series item, the 14, 15, and 16.
Hmm.
I appear for the respondents in item number 14 and for the petitioners in 15, madam. My
Yeah.
senior has some difficulty today, Mr. N.K. Chaudhary, madam. I'm praying for a adjournment.
Password remain on the board. Today, if he is having some difficulty, we'll pass it over.
Well,
It will remain on the.
I'll be here, madam. I'll be here. God bless. Thank you.
Lordship, I beg to mention item 13 because an IA was filed, Lordship. It has not come up yet. The IA has not come up yet. So maybe
IA for what?
for impleadment, Lordship, of
To
respondent.
whom?
Respondent, Lordship, this is a flyover matter in Diffu, and then the construction company, Lordship, we just obtained the
Flyover matter, the tender was floated in the year 2023.
2023, yes, Lordship.
23, it must have been completed by now.
No, no, not yet.
So it's going on.
Yeah, going on, Lordship.
Why to interpret? You are for the,
I am for the respondent, lordship. I am for KAC, lordship.
for
Karbi Anglong Autonomous Council.
what, how much this, this bridge is completed or what?
No, it's ongoing, lordship. It's going on.
Going on?
Yes.
How much work is completed?
I have to take instruction of that.
First over. First over.
Any other request?
Wait, please. Sir, I filed one petition, my lord, yesterday. But lordship may kindly consider for listing it on tomorrow.
Why? What's the other thing?
My lord, what has happened, it's a eviction matter, my lord. 13-4 notice has been issued with, along with a, my lord, order of district magistrate. My lord, I was served only on Thursday and I have been given
How listed in division bench?
surfacing matter, my lord.
It's completely matter.
My lord, what, I am
Tomorrow-
not challenging anything, my lord.
Then
Just I need 15 to 30 days time, my lord, for paying the.
approach the DRT.
My lord, only tomorrow's day is left. my
So if you can approach the High Court, why can't you approach the
lord.
DRT?
My difficulty is, the difficulty of the petition is he is not,
Why are you delaying the matter? Ultimately, prima facie, we are not going to interfere in the matter. I'm telling you.
he is not in a position to.
Check it tomorrow.
Tomorrow. I'm obliged.
Prepare a petition for DRT also.
Yes. I know, but the problem is that he is not having that much of money to pay the court fee also, my lord. That is the difficulty.
That you have to manage
My
any.
lord, he is only.
So
requested
you
in this
don't
time.
have the money to pay to the DRT, and therefore in 100 rupees or 125 rupees, you approach the High Court. This can't be the
My
case.
lord, 50,000 is required at this stage, my lord.
50 rupees. That's very easy.
50,000 is required, madam, for filing before the
Okay,
approaching.
fine, so you have to pay for that. It's a statutory provision.
Okay.
That's all.
Daily list for hearing item one.
Yes, submit Lordship. By the last order, Lordship, the Union of India was included as a respondent number 5, Lordship. In fact, Lordship, I have missed the matter. The union is not reflected in the cause list, DSGI or any. I missed the matter, Lordship. If it can be day after tomorrow, also. My name may be reflected in the cause list, Lordship.
Pass over.
My lord,
Now,
even-
it is passed over. Your name may reflect or may not reflect, you appear. in that.
Yes, I will
Pass
take
over.
note of that.
my lord, we are also appearing, we are also included party
Yeah,
in this. My lord, I have a instruction, my lord. We need 4 weeks time, my lord, to file the affidavit, my lord.
sir, on 14/5/2024, we have granted you the time.
My lord, we appreciate, my lord. Only on the last occasion, only, my lord, we were included as party, my lord. In this,
Last occasion,
Yes.
14/5/24.
my lord,
It's almost 2.5 months.
my lord, what happened, my lord? Department has sent this for,
We'll hear on that. Pass over. If your requirement is there.
Item three.
Lord, this pertains to casual laborers in BSNL.
Yes.
A series of litigation had gone on. The Honorable High Court, my lord, in page 99, Lordship would see, had remanded back the matter to the tribunal to consider the evidence of engagement and then pass necessary orders.
Yes.
Page 99, Lordship, para 37. Says that because of whatever has been discussed and pointed out, it is appropriate in our considered view. 99, my lord. It's part of a long judgment. I'm reading the operative portion. Starts from page 65, annexure 10. The operative portion at page 99, para 37. That having clarified the scheme for conferment of temporary status on casual laborers under 1989 scheme and also the 1999 scheme, the matter be remanded back to the learned tribunal, which has the requisite jurisdiction to adjudicate such disputed questions of fact.
Just a minute, just.
What we have discussed by the before. Yes,
My lord.
yes.
Matter be remanded back to the learned tribunal, which has the requisite jurisdiction to adjudicate such disputed questions of fact by recording evidence, which may be adduced by the parties concerned and or by obtaining such evidence as may be necessary for such decision in the case. So the engagement particulars, my lord, there is a cutoff date that as of 1/8/1998, if you have completed 240 days in service in a calendar year, then you would be considered for grant of temporary status under the scheme of 1989. So the dispute was, my lord, whether they had completed 240 days or not in a particular calendar year before 1/8/1998. The tribunal, my lord, thereafter does not discuss any such evidence. It just refers to some other order passed in some other case, and it says, my lord, that casual laborers are, my lord, otherwise vital and important, and this kind of general observations are made, my lord. Annexure 12, it starts with a type copy. The original is at 106B, probably, my lord, as per my pagination. Because a series of matters were transferred back to the tribunal accordingly.
July 2016.
16, my lord. The short order, but finally it says that referring to a order passed in another case, that they should also be considered.
Under a part.
But our grievance is that nothing as far as the engagement particulars, my lord, on record was considered, which is available at page 59, lordship. Page 59, internal committee of the BSNL, my lord. This was also constituted pursuant to certain orders of the tribunal earlier. These people, my lord, had never completed 240 days. In fact, the petitioner number, the respondent number 4 was never engaged also. And from June 1998, they were never in engagement, my lord.
Administrative member, he doesn't have any idea of. Administrative member.
This order has been passed by only the administrative member,
My lord,
single.
single.
Yes,
Engagement particulars are otherwise, my lord, as available with us is at case 59.
59.
Case 59.
What is it?
The number of days for which these persons are engaged, my lord.
That you have placed before the tribunal.
Yes, my lord, these were on record, my lord. But then never completed 240 days, my lord. It was up to them to produce any evidence to the contrary, my lord. That had also not come, probably by the way or because of the way the tribunal had disposed
This
the
is
matter.
in relation of all the. Only one person
There
is there.
there are 4 persons, my lord.
There are 4.
Page 59 is the first respondent.
Yes,
Page 61 is the second respondent. Page 63 is the third respondent. And the fourth respondent, my lord, there is no record available. It is a sporadic engagements, and from 1998 June onwards, my lord, they are no longer with us, my lord, in any manner.
Here.
yes, madam.
Lordship, somehow I could collect the phone number of the respondents here yesterday night and talked to them, and according to our discussion, they are still in engagement, Lordship.
Whatever it may be.
Thing
What
is
about
that-
this, madam? They are
Thing is
still
that,
in-
Lordship, they are saying that they have not completed 240 days.
Any evidence that they have completed 240 days which placed by these persons before the tribunal?
Yes, Lordship.
Where is that?
Yes, Lordship, that records are with the respondents, Lordship. But
Madam,
today I
here the
cannot
writ
produce.
petition, you must have filed a counter.
Yes, Lordship.
In that
We-
counter, whether any evidence that they have
We'll file,
completed
Lordship.
240 days before 1898 is placed on record.
Yeah,
from this counter to the writ petition, any evidence?
Lordship, may I pray for 10 days time, Lordship? I will
Madam,
file
for what?
affidavit, Lordship.
Whether you have placed any evidence of this effect that you have completed 240 days prior to 1898 before the tribunal, show us. And if you have not placed any such evidence before the tribunal, please show us whether you have placed any such proof evidence before this court.
Not before this court, Lordship, but
Then-
before the tribunal, we have produced the records.
Where is that?
That- That I will produce, Lordship. Kindly allow 10 days time, Lordship.
Yours, it's for hearing, madam.
Yes, Lordship, but
And where is the discussion of that evidence by the tribunal?
there is no such discussion, Lordship.
So since you have not filed any such evidence either before the tribunal or before this court. Where is your counter to the writ petition?
Kindly allow 10 days time, Lordship. I will
Yeah.
file 10 days time, Lordship. I will file counter.
You have not filed counter till date.
No, Lordship.
Please listen to this. You come out of your 10 days, 10 days, 10 days, come out. See, here the main controversy is whether your clients has worked for 240 days at a stretch before 1/8/1998. The division bench has earlier set aside the order and remanded the matter to the administrative tribunal to decide the issue on the basis of materials. The learned tribunal passed the order by a single member, administrative member. We find that it has been mentioned that Kandarpa Sharma's order was by the tribunal, but it was by the High Court. Be that as it may, the discussions are on the question of competence. Competence is not the issue here. Either the tribunal has to hold that your clients has worked for 240 days at a stretch or have not worked. Either the tribunal has to say that there is evidence and therefore this is the finding, or there is no evidence and therefore it cannot be recorded. Neither of these two things have been done here. So the order according to us is perverse. A fresh decision is necessary. If you block it, your clients are not going to get any relief. So the best course of action for both of you would be to get a reasoned order from the CAT at the earliest. We can remand the matter
Yes, Lordship.
with a request that it should be decided expeditiously within 6 months. If you are both agreeable to that order, it can be finished. that day. Otherwise, this 10 days and records and these and that is not going to take you anywhere. This will be just consumption of time of the court, nothing more than that. Yes,
In the Kandalpa Das lordship that is referred to here was remanded back a second time, my lord, by this High Court.
After the judgment on which the tribunal has relied.
That has been also, it has been also set aside and remanded back again.
Where is that? This PN number 39 of the 2009. That has been remanded.
That was remanded.
This 8/8/2014 order.
Yes, my lord. I only have the tribunal's order after remand, my lord. It says, my lord, by governor order dated 28/3/2018 in WBC 1273 of 2015 and other connected matters. All these matters were remanded.
We have the High Court order. Setting aside this 8/8/2014 order.
My lord, I have one copy, my lord.
Yeah, it gives the one copy.
Two copies.
पहले तो 2019 की 2012 what is ये order दिया इसलिए मैंने फिर High Court में order दिया।
Pandarbodas is the third case, my lord. Para 7 is the remand.
Just a minute, this Kandarappa Das,
Pandarbodas is the third case here, my lord. Lordship would see page 3
page
of the order, BSNL versus Pandarbodas and others, WBC 4127 of 2015.
transfer application over here. Para number?
Para 7 is the order for remand.
So the present order under challenge has been passed after the matter was remanded by the order dated 28/3/2018. Is that
This
correct?
was before, man.
Huh?
This was before. The order under challenge is of 2016 again. So this petition was already pending, my lord, but then not linked with these cases. And in 2018, my lord, this got remanded
the
and got
observation-
decided afresh.
Listen, observations made in the order dated 28/3/2018 also squarely applies to this order also.
Yes, yes,
So therefore, this is covered by this order.
yes.
Why didn't you say that in the beginning?
It's
You
kept.
gave an impression as if the second time it was remanded. इस समय ये भी इसमें आना चाहिए था कि ना वो
Remand this matter. Yeah. This writ petition is filed by the appellants, petitioners, challenging the order dated 14/7/2016 passed by the Central Administrative Tribunal Guwahati bench, hereinafter to be referred as bench, in transfer application number 25/2009. It stopped. The learned counsel for the party, it is noticed that the tribunal has disposed of the transfer application number 25/2009, relying on a decision of the tribunal passed in TA number 39/2009, Kandarappa, Das and another versus Union of India and another. Stop. Learned counsel for the parties have submitted that the judgment and order passed by the tribunal by CAT करते ना या hereinafter to be referred as tribunal ही करते ना. In TA number 39/2009, Kandarappa Das and another versus Union of India was subject matter of challenge before the division bench of this court in writ petition number 4127/2015, and the division bench has set aside the said order and has remanded the matter to the tribunal for a fresh decision by fresh decision. The operative portion of the order dated 28/3/2018 passed by the division bench of this court in writ petition number 4127/2015 is reproduced here under para number 6 and 7. In view of the above facts and circumstances of the case, we dispose of this writ petition in terms of the we are of the view that the reasons given in the above referred operative portion of the judgment are squarely applicable in the present case also. Hence, this writ petition is allowed. The impugned order dated 14th July 2016 passed by the CAT in transfer application number 25/2009 is set aside. The writ petition is disposed of in the terms of the order dated 23/8, what's the date? 28/3/2018 passed in writ petition number 427/2015 for
Fresh decision of the.
for fresh decision of the dispute regarding the grant of temporary status to the private respondents
As in pending in the OA number. As involved in the transfer application number.
involved in transfer application number 25/2009. Full stop. The tribunal shall pass fresh order expeditiously, preferably. We request the tribunal to pass the fresh order expeditiously, preferably within a period of 6 months from the date of production of certified copy of the order, this order.
You believe it.
Item number 7.
May I please, your lordship, Mr. D. Sharma, council sir is on next. Kindly the matter be kept for time being. Obliged, Lordship.
Not time.
Item 8 and 9.
May I please your Lordship, kindly pass over the matter for time being.
Item 10.
May I please, your Lordship, this writ appeal arises out of an outdated 1/6/2018 passed by the learned single judge. Matter relates to Lordship rental compensation in the state of Mizoram. And wherein Lordship at page 51, paragraph 6. If I may read. The assessment of rental charges for occupation of the land of the petitioners by the armed forces was assessed by the respondents number 6 for 3 periods. April 1966 to 31/8/1986, January 1987 to August 2008, and September 2008 to June 2011. Now the middle period, Lordship, that is a period from January 1987 and 2008. This is the period for which the dispute is. And it was assessed at the same paragraph for the second period of occupation under the Ministry of Defense. The amount was assessed at rupees 47,50,350 and odd. So this was accordingly, Lordship, at paragraph 7. In this view of the matter, the petition is disposed of with a direction to the respondent number 1 and 2 to arrange the fund for the payment of rental compensation to the petitioners to the tune of rupees 47,50,000 and odd. On the last occasion, Lordship, the state of Mizoram, they had filed an affidavit. And in the affidavit, Lordship, at running page 422, below part, an assessment has been made. At paragraph 7, if I may. Lordship.
Yes.
My friend was relying upon a paragraph 7.
Yeah.
To confirm that, Lordship, the amount of 47,50,350 is due. And they have given a chart in support of that. And it was precisely on this aspect of the matter that I was required to take instructions. Now, the period Lordship has noted, it is from
January 1987 to 2008.
2008. Now, if I may take your Lordship to my to the same judgment, impugned judgment, at page 47. At page 47, paragraph 13.
47, yeah.
Lordship has seen paragraph 13.
Yes.
This is extracted from the affidavit filed on behalf of the Union of India. And Lordship will see the payment made.
Yes.
We have Lordship in the Lordship will see the second payment, 1/1/98 to 31/12/2005. We have released an amount of rupees 50 lakhs 72,215.69. There's another installment given thereafter from 1/1/2006 to 2007. So this amount which has been sanctioned and released to the state government, that has to go to the beneficiaries. Because we do not personally give it, they have to distribute it to the persons concerned. So as it is, Lordship, we have given an amount.
How this para number 13, this single judge has taken into consideration and
This part of this amount has been paid. There is no discussion on that. This is simply an extract from the,
earlier order.
no, this is an extract from our affidavit in opposition. Now, where has this money gone to? In fact, Lordship will see the column below. What was the amount disbursed by the state of Mizoram? In fact, in the second payment, something less than what we have released has been given.
In the first payment also.
First payment
No,
also something
3
less
lakh-
has been given.
3 lakhs and another is around
Yes.
some 70,000-80,000 rupees.
Now, when I make a submission that we make the payment together, not individually, and the state has to give the benefits to whoever the
Disperse that amount.
beneficiaries are. If someone has been left out, how can we be saddled with that responsibility, Lordship? I may agree, Lordship, that there may be a discrepancy of a few thousand rupees here and there.
That's immaterial.
That's immaterial, Lordship.
This matter pertains to Aizawl bench.
Yes, Lordship.
Why has it been transferred here?
Lordship, perhaps at that point of time, there was concerned judge was sitting there. Because it's quite old, Lordship.
Ms. Bhattacharya, have you filed affidavit here on your state?
One affidavit file, Lordship. That is in, as per direction of this honorable court, Lordship, dated 2012-2022. There is a direction, Lordship, passed by this honorable court to file one affidavit, Lordship. State government in the revenue department, Mizoram shall apprise this court as to how and what
No, just
basis
a
and
minute,
who
just a minute.
quantify the amount.
The affidavit has been filed in the repeat.
Yes, Lordship, here.
That means this finding recorded by the learned single judge
Yes,
that no rent has been paid to the petitioners. That finding is not based on an affidavit.
no, Lordship, because initially we are not party in the present writ appeal. Later on, we are implemented lordship and directed to file one affidavit that is filed lordship. Only on the issue of that lordship, how and on what basis the amount was quantified lordship rental. That's only one affidavit, short affidavit was filed lordship.
It appears that the learned single judge
Yes.
has observed that though the payment was made by the central government or the whatever the authority concerned, but in the APRs, the petitioner's names are not included.
Yes.
If the petitioner's names are not included in the APRs, who prepared that APRs?
Actual paper receipt. Perhaps district administration lordship.
District administration, if the district administration has left out
Yes.
certain persons, how this Union of India is responsible for making double payment to those persons at the fault of the district administration? On account of fault of district administration?
That instruction is not with me, lordship.
That instruction, there is no question of any instruction.
Yes,
This
sir.
is only a question.
Yes, lordship. That is the question, main question, lordship.
So if they have made the payment and the responsibility of disbursement of whatever the rent is of the state government, how this Union of India can be asked to make double payment for that?
But in my affidavit lordship, which was filed before this honorable court lordship, where I have stated that that amount lordship since 1987 to August 2008, that was not paid by them to us lordship. That has to be paid
Is
by,
that finding that that payment has not been made?
yes, lordship.
In fact, this page 48, para number 15.
Para 15.
I have perused the actual pay receipts with regard to the rental paid
Yes.
to the private landowners in respect of occupied by the land for the period 1986 to 31st of December 2007. The payment of rent has been given in 3 phases to the landowners. The petitioners are not included in the APRs.
Then there was next paragraph, lordship, there is a joint verification report, lordship. And the affidavit submitted by the central government and the state government clearly points to the fact that petitioners' lands are within the area occupied by the armed forces. The Ministry of Defense have been consistently taking the stand that they have paid rental charges area-wise and for an area of so-and-so. However, the additional affidavit that is so-and-so submitted by the state respondent is to the effect that the land of the present petitioner covers an area of so-and-so square meter within the blueprint area. The additional affidavit, however, does not clarify as to whether the land of the present petitioner covering an area of so-and-so square feet is included within the area of 6.991 acres of the private holding recorded earlier, or whether the said so-and-so square feet is over and above so-and-so acres. The APRs annexed to the additional affidavit fixed by the state respondent on 7/4/2017 shows the area of private landholders. However, the calculation is not in accurate and disregard the state respondent will have to calculate the area of the private landholders as per APRs mentioned in the additional affidavit dated 7/4/2017. The area of the private landholder as given in the APR will clarify whether the private landholding come to 6.991 acres and whether the petitioner lands are over the above the 6.991 acres. In this regard, learned government advocate she will submit additional affidavit. Then one additional affidavit was filed, lordship. Next. Additional affidavit state respondent in terms of the order dated so and so by the state affidavit, the state respondent have contended that
Will continue. At 2,
yes, sir.
clarify the position. Item number 10.
10 Lord.
Next Tuesday.
May I plead your lordship? I
Yes.
beg to mention item number 8 and 9.
Yeah.
Lordship, I need only accommodation for today, lordship. This matter is led by Sri Kiran Chaudhary
Next Thursday.
next Thursday. And similar pair in item number 12 and 17 also.
Lordship, in that case, I have an objection, Lordship, because there is an urgency in that matter.
Which one?
Item 12.
17.
Item number 17. Yes, if you have objection, then wait for your turn. Wait for
Lordship,
your-
actually, today general meeting is going on and this matter is led by Sri Kiran Chaudhary.
Still
Lordship.
the matter is,
Yes, Lordship, also. Yes, Lordship.
the matter is there. Yes.
Lordship, my friend has just mentioned
Lordship, in item number 12, there is an interim order, Lordship.
Lordship, in item 12 also, there is an urgency on behalf of the private respondent. There's an interim order operating against us. So we also have some urgency in.
It's eight, fixed on eight. Next
Yes.
week.
That's right.
Let's wait for it. If the objection is there, either you get the consent order, otherwise they'll hear.
So, Lordship, item number 10, my friend had just mentioned,
Item number?
10, it was going on, Lordship. My
Item
friend had
number 10.
10, he has just mentioned it was,
How you can mention the matter which is going on since last half an hour?
Lordship, I understand I had paid for accommodation.
No, please, sorry, sir. We are in the midst of the argument. How can it?
May I please your lordship? Lordship, I beg to mention item number 7. This matter may be adjourned for this day, lordship.
In the morning, they simply said.
Yes, lordship, I am extremely sorry. Yesterday, lordship, I overlooked the matter in the first list. That's why, lordship, I was too late today, lordship.
You are,
Lordship, I am for the appellant, lordship.
you are for the appellant, you were busy in the morning in some other court.
Lordship, but in my, through my junior lordship, I have to put in my, I have to send him here because that matter was, lordship, I have to. That's all.
Still the matter is going on.
No, lordship.
Then
This is only for today, lordship, accommodation is required, lordship, because in this matter will be led by a senior advocate, lordship. In the last occasion, I have mentioned before your honorable court that earlier this matter was led by Justice UK Nair, and I have.
Thursday.
Thursday, on eight.
Today.
Thursday.
Highly blessed.
Yes.
Item 10.
May please your lordship.
Private lending. Chaudhary,
Lordship,
Leonard Singleton has recorded a finding.
Lordship,
That is the page 50, this judgment, para number 4, just para above the para number 4.
yes, Lordship,
It was therefore last 3 lines.
yes, it was
It
therefore,
was therefore considered
yes,
that the lands of the petitioners were within army occupied area, but not within the 6.991 acres of the said said to be army occupied area. They have specifically recorded this finding that their land is out of that 6.99 acres of the land.
yes,
Yes, then, but the same was occupied by the army.
Lordship, if I may take your Lordship to 6.99 is a part,
Is a
is a part of the total area.
total area was
I'll just. Uh, yes. If your Lordship will come to page 5 of
5 of what?
the memo of appeal, Lordship, paragraph 2.5.
Page 5
Of the memo of appeal, Lordship.
memo of appeal.
Yes, Lordship, I have explained that in paragraph 5, 2.5.
Yeah.
The appellants begs to state that as per the 1992-93 board proceedings, 4.704 acres so and so of land was under the occupation of the army at Bangkwal. Out of the same, a total of 6.991 acres, 6.991 acres, Lordship has taken note of.
That board proceedings have
Where-
also been taken into consideration by
Where-
the Leonard single judge.
These were private lands. It is not disputed that it is, the state has not said that more than this is private land.
Sir, now what we understand that total land in occupation of the army was 37.704 acres,
Flush.
out of which some 24 or 27 that is government land. That was government land
Yes.
and rest is the
Six
private.
point
land.
991 is private land. So for private land, Lordship, we have paid. Now,
But now the finding is that this is beyond the area of 6.9991 acres.
now, the state does not say that,
State says,
no,
state says. Para number, this, 3 of the judgment.
yes,
Thereafter, the learned has filed an additional affidavit in terms of the order dated so and so. By the said affidavit, the state respondents have contended that the land of the petitioners are not included in
yes,
6,991 acres of the private land as recorded by the board proceeding so and so. However, the joint verification indicates that their land are within the blueprint area, the area occupied by the army.
yes.
The first APR for the period do not provide the details of land holding, but only contain only amount sanction that was sanctioned so and so. The second part of the APR contains details of the land and amount sanction. That they are the same. Although there is a slight variation of the land amount sanction, the disbursement tally with each other. Therefore, the variation of the negligible. It is further contended that an error apparently appeared in the report of the board proceedings wherein the government free land was indicated itna, and that the land of the petitioner were perhaps within this area. It was therefore considered that the land for which the petitioners were within army occupation, not within the so and so area.
This was the stand of the state. Lordship will come to
This was
paragraph
the-
4. Lordship will come to paragraph 4.
Para 4, yes.
Refuting the contention of the state respondents in the affidavit so and so, the respondent numbers 1 and 2 file an additional affidavit on 16/5/18, reiterating that as per 1992 to 1993 board proceedings, 34.704 acres so and so of land was under the occupation of the army at Bankwal. Out of the same, a total of 6.991 acres, 21.147 bighas were private holdings in the form of land settlement certificate passes. The balance 27.713 acres, 83.83 bighas was government land. Since the Ministry of Defense has already paid its liability towards rent of 6.991 acres land, there was no further liability. Moreover, the private lands have since, this is the had.
So you are not disputing that the petitioner land was under occupation of the army.
Lordship, I have raised a point in my grounds. The petitioner's land passes were issued only in the year 2004. Now, if it is issued in the year 2004, Lordship, we were in possession. How did they come in?
But your joint verification report finds that their land was occupied by the
Army.
defense.
Lordship,
That is a report prepared by your personnel.
Lordship, the land in total which is occupied by us, whether the compensation has been paid, we do not say that this person's land has been occupied or that person's land has been occupied.
No, Mr. Devchand, you see, these are all jargons. Let's not go into that. 6.99 acres, we don't understand more than that. We
Yes.
have
We
occupied
have occupied and we
6.99.
have paid.
Whether it is there or who is there, we are not concerned.
Lordship,
But you have to answer the dispute. The dispute here is that the learned single judges found that you were in occupation of their land, which was in excess of 6.99, because that is These findings are supported by the joint verification report. Answer that point, not what you're saying. What you're saying is of no relevance here.
Where is the joint verification report?
Lordship.
Where is that?
Hold on.
Lordship, page 364, record 364.
No, record.
Record.
Defense estate officer. What is DEO?
Defense Estate Officer.
What was it? RR Das. Joint verification report was not signed by any officer from the defense.
No.
Huh?
No, not to my knowledge.
Please check it and say. Colonel MC Babu is not from defense.
Lordship, so far,
Station headquarter Aizal.
no, so far as Lordship, the estate matters are concerned.
Hmm.
He might be a commanding officer. The estate matters are looked after by the Defense Estate Authority.
Maybe, but the defense personnel, the
But
authorized person is there.
Lordship can interpret it in that manner.
Have you challenged this report?
No.
No.
Then the only question here is on a short campus.
Lordship,
Did you occupy their land for that period? If so, they will be entitled to receive rental compensation. So have you already paid that? That answer is clear. You have not paid. 6.99 is what you have deposited with the
Yes.
government. So if their land is beyond 6.99, you have not paid that compensation. This is number one. This is automatically established. So the only question to be established is, did you occupy their land, which was over and above the 6.99 acre of private holding? The joint verification report says yes. That has not been challenged.
Lordship, apparently that has not been
Then you
challenged.
have to give the shortfall, as simple as that. Where is this original report, joint verification report?
That is the
Original joint verification report.
That is not with me, Lordship. I have to.
This 7th of December, 9th of July, June 2011. Page 167, na? 168. If it contains the signatures of army officers,
Yes, Lordship.
then let us just here. Original है,
not with me, Lordship.
call for it. Call it.
Lordship.
Oh, madam, you please bring that original.
Yes.
Learned counsel appearing for the learned additional advocate general appearing for the state of Mizoram is directed to produce the copy of the original original report of the original joint verification report prepared on 9/6, prepared on prepared pursuant to
Order dated 1810.
the order number F 15012/1/97 BC in bracket A/164 dated 18/10/2011 passed by the Deputy Commissioner Aizawl District, Aizawl for implementation of the judgment and order dated 9/6/2011 passed by the Guwahati High Court. When
2 weeks, Lordship. Any date after 2.
list on twelfth of August,
Yes, Lordship. Obliged.
it's on 12th of August.
Item 11.
Item 11. For whom are you waiting? Item 11 was called and you were sitting there.
Sorry, Lordship.
Yes,
Lordship, the issue raised in this PIL is that the passenger safety of the passenger of railway who are traveling in the Silchar-Lamding route. Lordship, this route was converted from MG to BG in the year of 2015. And before conversion, and after conversion, before running of the passenger train, the CRS inspection was conducted. CRS means the Commissioner of Railway Safety. And the CRS has submitted a report to the Railway Board, whereby the CRS Commissioner opined that the line is not fit for the passenger train, and they have suggested certain safety measures and told that until or unless these measures are adopted, the passenger train cannot run over the line. Accordingly, without complying the CRS report, the Rail Board condoned the suggestion forwarded by the CRS and safety certificate was issued. Train started running over the line, and it resulted in every year huge landslide every year, the people of the Borakpuli region suffered due to the landslide, and train communication became paralyzed because the non-implementation of the CRS report and that's adequate safety measure. And they, railway side have also submitted one affidavit in opposition. They have stated that they have adopted adequate safety steps to ensure the passenger safety. Lordship, this, their affidavit, it contains lot of technicality. It involves some technical analysis, and being a lawyer, I am not competent to argue on this matter.
So
But-
being a judge also, we are also not competent. Do you
Yes,
expect from us?
Lordship, my simple
The lawyer is
submission.
not able to assist the court on these technical aspects.
What is this All Bharat Youth Student? What is this organization? Who is the petitioner here?
Is the convener of this organization, Baharul
This
Institute.
is a registered society.
Yes, Lordship. So for
Show us the registration certificate.
registration. Perhaps this registration certificate is not annexed.
No, if it is not annexed, then it will be difficult.
Second, it is not even written in your petition that it is a registered association. Simply said, All Barak Student here is founded in the year, is a non-governmental organization, was one of the first to make inroads in social discrimination, injustice and so and so. So. once there is a-
Lordship, if Lordship give me some time, 1 week or 2 week, I will obtain the registration.
No, now there is no question, now it's in the hearing. And this affidavit is filed by the railway, wherein they have said they have taken all the measures. What remains then?
Yes, that is why I'm coming.
Yeah.
I'm assuming that they have taken adequate safety steps, assuming. But my issue is that if the adequate safety steps are taken, if the adequate safety measures are taken, then why it is happening again and again in every year? Daily?
That is, that they'll take care of that. That they'll take care of that.
They will take care of that. That is true, Lordship. And in fact, they are also taking care. But my submission is that it is not sufficient.
What do you expect from the courts? That is ultimately as per their, whatever the standards, they have to maintain all these things. Ultimately, it's not the case of the railway that we are, despite all this, we will run by this. At the most, if it is not feasible, then they'll close the route.
No.
Or what
I
else
must-
they will do.
I-
They close the route. If it is not feasible for them to run train on that, then they'll close the route.
Lordship, this is not my issue. My issue is that
Have you ever taken a journey in a train from Kachar to,
yes, regularly.
where is the statement?
You, not you means petitioner.
Lordship, this statement is not available, but the petitioner belong to that, he is from Silchar. So it is quite natural that he, whenever he used to come, Yeah.
Whatever it may be concerns raised by him, maybe we are not disputing that, yes, those concerns are genuine. But now, when the railway has come with a specific reply that they are doing all these safety measures and as per the instructions or by the technical experts, then what remains?
no, this is the issue, Lordship. If this railway, I am not telling that they are not doing anything. Yes, they are taking, but the issue is that whatever they have taken, is it up to the mark or not? If it is up to the mark or sufficient, then
Now, who is going to this claim that it is not up to mark? You said you are not technical person
absolutely.
and we are also not technical persons. We have to rely on them.
Then the railway may give declaration before the court that they will ensure the passenger safety of this route.
That will. This petition is filed by the Petitioner Association, the petitioners raising a grievance regarding raising with the contention that the respondent railway be directed to execute safety measures in the hill section of Lumding Badarpur railway line and Badarpur railway line. Stop. Several instances have been mentioned in the writ petition alleging that the railway authorities are not taking appropriate safety measure for conducting train operations in hill section of Lumding Badarpur railway line. Affidavit in opposition is filed on behalf of the railways, wherein it is contended that the railways are taking all security measures as per the instructions of the railway board and the senior superior authorities for GHY/SCL railway segment. The measures carried out by the railways have been mentioned in detail in the affidavit in opposition. Having heard the learned counsel for the parties and after going through the pleadings, we are of the view that the railways has taken several measures for safety of the train operation in GHY/SYL railway railway segment, GHY/SCL railway segment. Stop. Mr. Chakrabarti, counsel for the railways, has submitted that the railways shall that in future also the railways shall adhere to all the security measures required as per the standards and continue its efforts to have the rail operations on the said segment smoothly. Full stop. In view of the above facts and circumstances of the case, no further order is required to be passed in this PIL petition. The same is therefore closed.
One more submission.
What?
Can I pay for the?
That these petitioners should be allowed to travel free in the
No, no,
railways. So
I'm just praying liberty to approach the court again if necessary.
there is no, we have not curtailed your liberty at all. Whenever you will file, at that time you'll see.
Lordship.
Item 17.
This lordship, I'm praying for an adjournment lordship in this.
Thursday,
Thursday, at 2 o'clock, Lordship.
timing,
Uh,
think so.
Your junior can make a mention.
at 2 o'clock, Lordship. Hello.
And inform the other side also.
Yes, Lord.
Yes,
Yeah, tomorrow.
First,
yeah.
one.